name is Lisa Tepper Bates. I'm the president and CEO of United Way of Connecticut. And on behalf of the Connecticut United Way Network, I want to thank the Connecticut Paid Leave Authority for hosting today's webinar on the Connecticut Paid Family Leave Program. I want to also thank you, all of you who made the time to join us today for this important presentation. And finally, I want to thank Andrea Barton-Reeves, CEO of the Connecticut Paid Leave Authority, for leading the Connecticut Way Network and our partner organizations through this important presentation. And just to set the stage, I'd like to take a step back and remind you about how the dots connect to the work that United Ways are doing across the state. In September of 2020, Connecticut United Ways released the 2020 ALICE report, our fourth ALICE report for the state on Connecticut families struggling to make ends meet. These are families who are asset limited, income constrained, and employed, or ALICE. The 2020 Connecticut ALICE report revealed that even before the onset of the COVID-19 pandemic, 38% of Connecticut households were walking a financial tightrope and struggling every day to pay their bills, to keep the roof over their head, to keep food on the table. When we talk about ALICE, these families struggling financially, it's important to recognize that we all know ALICE. ALICE is the essential healthcare worker caring for our aging parents at home and for COVID patients in our hospitals. ALICE is the teaching assistant who helped our children adapt to virtual learning, or the bus driver who gets our kids to school. ALICE fixes our cars, and she works in our local shops and restaurants. ALICE is our friend, our neighbor, our coworker, and our family member. From the Connecticut United Ways 2020 ALICE report, we know that more than 50% of workers in Connecticut are paid hourly. And we know that these hourly workers in particular, and those who are on-demand or gig workers and contingent workers, are less likely to receive benefits such as health insurance, paid time off, family leave, or retirement contributions through their employer. We also know that being asset limited, lacking any substantial savings, is a defining characteristic of our ALICE demographic. More than 1/3 of Connecticut households are without any financial cushion at all, and they do not have enough income to cover current expenses, let alone the costs that often accompany unexpected emergencies. This vulnerability means that an illness or injury can send an ALICE household spiraling into poverty. While this was all quite clear to us before the COVID-19 pandemic, this public health emergency has only served to underscore how crucially important it is for Connecticut residents to have access to the paid medical and family leave that would allow them to recuperate from a serious illness or care for family members who are doing so. Fortunately, in 2019, the Connecticut legislature and Governor Lamont together passed into law a strong, comprehensive paid family and medical leave policy that ensures that all workers will have the ability to take time to address serious health and caregiving needs without putting at risk the financial stability of their families. Prior to the passage of the Paid Family and Medical Leave Act, just 17% of all Connecticut workers had access to paid family and medical leave through their employers. Only 6% of low-wage ALICE workers had access to a paid medical leave option. The passage of the Paid Family and Medical Leave Act creates a path for Connecticut's ALICE workers to care for a loved one or themselves without having to worry about losing critically needed family income. That legislation and the creation of a new paid family and medical leave authority under the leadership of Andrea Barton-Reeves represents a momentous step forward for ALICE families in our state and for Connecticut as a whole. During today's webinar, we will learn about the new paid family and medical leave benefit and about how this benefit will be rolled out in Connecticut. We'll discuss how Connecticut paid leave will impact businesses of all sizes as well as their employees. We'll gain an understanding of which employers must participate in Connecticut paid leave. We'll discuss who will be eligible for paid leave, and we'll review the resources available to support implementation. I'd like now to introduce Andrea Barton-Reeves, Connecticut's first Chief Executive Officer for the Connecticut Paid Leave Authority. Andrea began her tenure as CEO of the Connecticut Paid Leave Authority just this past March. Prior to assuming this position, Andrea served as president and CEO of HARC, Inc., a leading nonprofit provider of services for people with intellectual and related disabilities and families in the Hartford area. Andrea has a long and distinguished track record as a leader. Prior to joining HARC, she served as the Director of Program Operations at Lawyers for Children America, Inc. And Andrea was the first African-American president of the Connecticut Bar Foundation. In addition to that, she has served on the boards of a number of nonprofits, including as board chair of the Village for Families and Children, and as a member of the boards of the Connecticut Community Nonprofit Alliance and Leadership Greater Hartford. Many of us in Connecticut have had the privilege of seeing Andrea at work in her previous leadership capacities, and we know that Connecticut is very fortunate indeed to have her incredible skills and talents at work as she leads this wholly new and important effort to stand up the Connecticut Paid Leave Authority. Thank you, Andrea, for being with us today.
Thank you, Lisa. You're very kind. I appreciate that. It's really my honor and privilege to do this work. I believe in it strongly, and thank you to everyone who is attending today. I have a very soft spot in my heart for United Way and 211. In particular, when my son was very young, he's now 20, but when he was in the ages of birth to 3, 211 is where I called because he wasn't talking at 2, right? And I needed access to services, and the first person, the pediatrician said to me, "You need to call 211 and they'll be able to help you." And they did, and we got a terrific person, and now he's more than talking. Let's just put it that way. Right now he's doing well. So thank you. Also, I do have to say that when we're in the course of launching the Paid Leave Authority, we found ourselves in need of support to address issues and concerns that were raised by people who were registering or going to the website and had questions and concerns. And the very first place that we went was to United Way, because we'd had such a wonderful experience, because you've done such an extraordinary job in supporting all of our citizenry during the COVID crisis, providing information in a timely and compassionate manner. It never dawned on us to go anywhere else in order for people to get that same level of support when they were interacting with our agency, because we knew that you understood what Connecticut needed and that you would have an opportunity to treat people as they were learning about this process with the dignity that they deserved. So we're just delighted to work with Kate Quigley and her staff at United Way, who've done an extraordinary job for us and continue to do that. So I want to publicly thank everyone for the work that you've done. So I am going to share my screen, and we're going to go ahead and get started, and I will talk to you today about paid leave. Let's see. So Amber, is my screen visible?
Yes.
All right, wonderful. So I usually, so I'm not a distraction, take myself off of the camera, and then, okay, off we go. So again, thank you for the opportunity to talk with you today about paid leave. So you want to cooperate with me today? Or there we go. So Lisa talked a little bit about my background, so I won't review this slide again, other than to say I'm just really delighted to be the person who was selected to implement paid leave. During the 10 years that I worked at HARC and the time that I also represented children in delinquency and child protection matters, I've seen so many families that could benefit from paid leave, so I'm really excited to just be a small part of making it possible in the state. Today, we will talk about the LEAVE program overall, some key dates that employers should be aware of, an overview of the law itself, how you would apply the paid leave benefits in your work environment and your role as an employer, some examples of how you'd put it into practice. I'll show you where you can find some additional resources on the website, and then we'll have an opportunity for questions and answers. So let's start a bit about talking about the Paid Leave Authority itself. As Lisa mentioned, it was enacted through a statute that was passed and signed into law by Governor Lamont in July of 2019. And we have a primary purpose of serving a growing need that we see not only in Connecticut, but across the country, that allows some financial relief to families so they can have an opportunity to care for themselves or their loved ones without having to worry about lost income. And our mission is twofold. We provide pathways we provide pathways to accessible paid leave benefits. And we also do our best to empower employers and administrators and healthcare providers in administering the program by offering you helpful tools so you can understand your role and navigate the program. We have 5 primary responsibilities at the Paid Leave Authority. One of them is outreach and engagement, and that's why we're so delighted to be here with you today so that we can teach and share what we know about paid leave. We're also responsible for developing the policies and the procedures needed to run the program. We established the trust fund contribution rate, which is 0.5%, and we receive those contributions. We audit and approve private plans for those employers that wish to offer a plan in lieu of participating in the public plan. And finally, we're responsible for administering the claims and benefits under the paid leave program. So who is covered under this program? Statutorily, employers that have one or more people working in Connecticut, and that includes nonprofit employers and private sector employers with a unionized workforce, are covered under the paid leave program. Those who are sole proprietors or self-employed individuals can choose to opt in, but if they do so, they have to remain in for a minimum of 3 years. Generally, those employers who are not covered include the federal government and some state of Connecticut employees, with the exceptions being made for covered public employees, and I'll review that in a moment. Municipalities, as well as local or regional boards of education, are also excluded from coverage as employers under this plan, as are non-public elementary or secondary schools. As you note here, municipalities and local or regional boards of education are exempted unless they have covered public employees similar to the state of Connecticut. So here you'll see that a covered public employee is defined in several ways. They are, with respect to the state, all the managerial or non-unionized employees of the state. They are covered. Unionized employees of the state who collectively bargain to be included in the program will also be contributing and participating. Employees of municipalities or local or regional boards of education will participate if the unionized employees of both of those employer entities collectively bargain to be included. If they do so, then all of the employees of, say, the municipality or all of the employees of the local or regional board of education will then be included whether or not they are in the bargaining unit. How are the contributions that we're collecting starting January 1 of 2021 managed? So you may have seen or heard announcements on radio and television speaking about the 0.5%. And this essentially is the cycle of those contributions. They're collected by employers, and then that contribution is remitted by the employer on behalf of the employee to the Paid Leave Authority. We receive those contributions and we validate the wage information by access to information we have from the Department of Labor and the Department of Revenue Services. Those contributions are deposited into the Paid Leave Trust Fund, and that trust fund is managed by the Office of the Treasurer, and it can only be used to pay benefits and to administer the paid leave program. The trust fund then, in fact, provides benefit payments to those who are eligible, and contributions continue to be withheld so that the fund can remain solvent and available for benefits. Here are some key dates that employers should know about. Our website, which was launched on September 4th, remains available and has an abundance of information for employers, employees, sole proprietors and self-employed, third-party administrators, and healthcare providers, all about the paid leave program. We had strongly encouraged every employer to register by December 31st. If you have not registered, you may still do so by going to the site ctpaidleave.org, which is the same place where sole proprietors and self-employed individuals may also register. We know that employers are required to withhold 0.5% of wages and remit those to the Paid Leave Authority starting on January 1 of 2021. And then in January of 2022, benefits will be made available to those who contributed to the plan. Going into an overview of the law, who is covered and why? So here are the reasons for leave. You can take leave to create or expand your family through birth, adoption, or foster care. You can also take leave to care for a family member that has a serious health condition or for your own serious health condition, which can include serving as an organ or bone marrow donor and also for pregnancy. There may be an additional 2 weeks of leave available if you have some incapacitation or complication due to pregnancy. There's special leaves available for family members who are injured during active duty so that you as the family member can provide leave to that person who is injured during active duty. There's also qualifying exigency leave that's available so that family members can be together to see off a person who is deployed overseas. And finally, what is unique to Connecticut's law is up to 12 days of leave is available that is paid to deal with the impact of family violence. Taking a look now, let's just compare what Connecticut's current FMLA looks like and what it will look like when the law comes into effect in 2022. Right now, our current Family and Medical Leave Act applies to employers with 75 employees or more. And in order to access those benefits, those employees have to have worked at least 12 months with an employer and 1,000 hours. And after that time, they would have job protection, meaning the ability to return to their job after 12 months. They would also be able to get 16 weeks of leave in a 24-month period. And the employer can require the employee to use all of their accrued time off in order to cover any time that they're away on family and medical leave. In 2022, there are substantial changes to the law. First of all, as we mentioned earlier, the threshold of coverage drops from 75 employees or more to 1. There will no longer be an hours worked requirement for qualifying for family and medical leave, and job protection will be available after 3 months rather than 12. There will be 12 weeks of leave available in a 12-month period, with the exception of 26 weeks of leave available for military caregivers, with only 12 of those weeks being paid. And as I mentioned earlier, an additional 2 weeks of leave may be available for incapacitation during pregnancy. And finally, another significant difference is now where an employer can require an employee to exhaust all of their accrued time for FMLA, that will no longer be the case. An employer can require their employee to use some of their accrued time, but they have to allow the employee to keep up to 2 weeks of their accrued leave. Taking a look at those laws that provide protection for job protected leave, the federal FMLA, which applies to employers that have 50 employees or more, remains as it is. We have covered the differences between Connecticut FMLA as it exists now and what it will look like in 2022. Workers' compensation, the Americans with Disabilities Act, the Pregnancy Disability Act, and Connecticut's Fair Employment Practices Act all remain viable laws in our state, and remain also some options to provide for a reasonable accommodation for an employee that may need leave that might not otherwise qualify for FMLA. The laws now that provide for income replacement will still include workers' compensation, and now in 2022 will include the Paid Leave Act, keeping in mind that employees who are eligible for workers' compensation and are receiving workers' compensation benefits are ineligible to receive compensation under the Connecticut Paid Leave Law. The primary difference between the federal FMLA and the law in Connecticut, when it comes into effect in 2022, is the definition of family, which is much more expansive. So rather than the fairly restrictive definition that you see above, particularly with respect to a child under 18 or one that's over 18 that has a disability, our new law will have a definition that includes parents, spouses, sons or daughters of any age, siblings, grandparents, grandchildren, and an individual that the person considers to be family, either by blood or an affinity, that has an equivalent relationship to other family relationships. So what exactly does that mean? Here's the definition of related by affinity. It is any person with whom the employee has a significant personal bond that's like a family relationship, regardless of the biological or legal relationship. And obviously, this is situational. So the one that seems most relational would be the bullet that's second from the bottom. Or you may have an unmarried significant other of the employee with whom the employee maintains a familial or spouse-like relationship, despite the fact that they may not have a legal relationship, meaning that they are not married or not in a civil union, which our state no longer recognizes, excuse me, because it recognizes marriage. In those instances, the person may have been living with someone for quite a long time and consider them their spouse. And if that person falls ill, as our laws currently read, your employee would not be able to take time off to care for them. But when the law changes, they will be able to do so. But that obviously will be on a case-by-case basis. Looking at the lengths of leave, they don't change for federal. They're still 12 weeks in a 12-month period and 26 weeks for caregiver leave. As I mentioned earlier, it's 12 weeks in a 12-month period for job protected leave starting in 2022. And as I'd also mentioned before, the 12 days for family violence and up to 2 weeks of additional leave for incapacitation due to pregnancy. And to access paid leave benefits, those amounts of leave are also the same. Reviewing just again the eligibility requirements, federal law remains unchanged. Mentioned earlier, job protection, meaning the ability to return to your job, or if that job no longer exists, an equivalent role, is provided to an employee when they've been with an employer for at least 3 months and there is no hours worked requirement. In order to access paid leave benefits, however, the person has to have earned at least $2,325 in the highest earning quarter of the past 4 of the 5 quarters, and they have to either be currently employed and working in the state, or they were employed and working during the 12 weeks immediately prior to the time that they applied for leave. They're a sole proprietor or self-employed individual who's opted into the plan, and they have to have a qualifying reason for the leave. How does this work as an employer? So when a person comes to you and asks for leave, it's really important to ask 2 questions and to ask them simultaneously. The first is whether or not that employee is eligible for job protected leave under one or more statutes, and whether that person is eligible for any income replacement while they're on leave. And it's important to ask both questions each time because depending on the law that you apply, the answers could be different and change the advice that's given to the employee. Job protected leave, as I'd mentioned before, could be offered under federal, FMLA, or state, or both that run concurrently. Neither of them, but perhaps under the Americans with Disabilities Act or pregnancy disability, or there could be no job protected leave at all. As we mentioned, these are the criteria for leave under federal and state, and then also asking yourself whether or not there's any other kind of job protected leave for which the person may be eligible. Then you ask the question about income replacement, and here are some important facts that you should consider when thinking about income replacement. So employees can in fact receive benefits from both the paid leave authority and maybe a short-term disability policy that employer may offer, but the combined benefits can never exceed 100% of the employee's regular wages. Generally, the policies that are offered by employees require that the short or long-term disability policies be exhausted first before they come to, that the state benefits be exhausted first before any employer benefits are exhausted. So this is just a call out to make sure that you check the terms and conditions of your short and long-term disability policies. As I mentioned before, a person who's receiving workers' comp benefits may not receive benefits from the paid leave authority at the same time. Here's an important point that employers need to know. A person may be eligible for paid leave, but may not have the job protection, meaning they've not worked with you for the 3 months. And here's how that might work. Because the statute says that a person is eligible for paid leave benefits from the authority if they've earned the requisite amount of money, the $23.25 in that base period, they've worked for the 12 weeks, either currently or they have been immediately prior to the time they apply for leave, and they have a qualifying reason for leave, they could be eligible for paid leave benefits, but they may not have job protection. So they could have met all of these criteria and then in a previous set of employment circumstances, and then come to you in month 1 of employment with you and say, I need to take leave, because I otherwise qualify for paid leave, but I don't have any job protection because I've only been here for a month. You as the employer can then say, okay, you can take the paid leave, but we're not going to hold your job for you, or we will hold your job for you, or you can reapply or make some kind of other determination regarding their job. but that's important to know that people can take leave even if they don't have the protection. We'll talk a bit more about private plans, so I'll return to that. And also just talking about the required use of accrued time. I'd mentioned that earlier. So employers, if your policies still say that you can use, that your employees have to use their accrued time for family and medical leave, you can still require them to use that for their sick or their vacation or other PTO. For those of you that may offer unlimited PTO, and we've had some employers do that, it may mean a change to your policies. But in 2022, just know that when employees take FMLA, they are entitled to keep up to 2 weeks of leave. Although you can require them to exhaust their sick leave, if they have vacation or other PTO, they're entitled to keep 2 weeks of that. So how does this work, applying for benefits from the Paid Leave Authority? The way it works is this, that the employee submits their application for leave from their job to you, the employer. They're not going to come directly to the authority and just disappear, because this is always a challenge that I hear employers are very concerned about, and rightfully so. You will then make a determination as to whether or not that person qualifies for leave and grant that leave. Let them know of any short-term or long-term disability options they may have to provide income replacement. If the employee does not have any of those options, or if there are other options that they're exercising in concert with paid leave benefits, they are responsible themselves for coming directly to the Paid Leave Authority to apply. That is not an employer responsibility. We then do a number of things. We validate their eligibility based on the statute, and we also confirm with the employer that the reason that they're seeking benefits is one that's covered under the statute, and that the employer actually knows about the absence that the employee is intending to take. And we also ask about any other offsets that they may have to the benefits and their paid time off, the benefits that will be paid during the time that they will be away for family medical leave, and then we issue benefits payments. So what is the formula for paid leave benefits? How much will a person actually get? If they're making less than or equal to the minimum wage, they get 95% of their base weekly earnings. If they're making more, the formula is a bit more complex. They get at least the 40 times the minimum wage plus a bit more in a formula that's outlined in the statute. Here's an example of both of those. So we have Mike here who makes $375 a week, and that we can see is less than 40 times the minimum wage. So he would receive $356.25 a week, which is 95% of his weekly wage. Deborah makes considerably more, so she receives at least the $480 plus 60% of the difference between the $480 and what she makes, which is $220. And when you add that together, she gets $612 a week in benefits. And I will make these slides available so that if someone needs to review that again, you can do that. All right, so now let's think about paid leave in the workplace. You have people coming to you and asking for time off, and how does that work? So we have Mr. Coyote here, who's working for a large employer, 100 employees or more, so we know that he's covered under the statute. He has 4 weeks of sick leave and 2 weeks of vacation. He's injured his hand, and applying that two-part analysis of whether he has job-protected leave or he's eligible for income replacement, what does his scenario look like? So it looks like this. Because he's worked for the employer for so long, we do know that he qualifies for both federal and state FMLA, and we're talking 2022 now. He has 4 weeks of sick leave, which the employer can require him to use. He can exhaust all of his sick leave, but we cannot require him to exhaust his vacation. So in order to cover the remaining 4 weeks of his time away on FMLA, he can seek wage replacement benefits from the Paid Leave Authority. And we'll contrast him to Jamie, who works for a smaller employer, and she works part-time. And the reason we raise this is that the person's employment status is not a relevant factor with respect to eligibility. It applies to full-time and part-time employees. Jamie's worked for 2 years. She has only six days of sick leave and 3 weeks of vacation. Then she injures herself running with her dog. Again, thinking about the two questions that we need to ask ourselves about job protected leave and income replacement. This is what Jamie's picture looks like. She is ineligible for FMLA because although she's worked for the employer for 2 years, she has not accrued enough time or hours worked in order to qualify for federal FMLA. But because she's worked for 3 months for the employer and in 2022, and there's no hours worked requirement, she does qualify for FMLA under the state law. She here now can use all of her sick leave accruals and a portion of her vacation, and the rest of the time, in order to receive wage replacement, she will seek that from the paid leave authority. For those of you who may have spouses who work for the same employer, under both federal and state law, those spouses are required to share their 12-week job protected leave. If under federal law, they're taking it to bond with a child that is new to their family or to care for a parent, and under state, again, to bond with a child that is new to their family or to care for a family member. But under Connecticut's new leave law, these spouses will not be required to share their 12 weeks of paid leave benefits for any reason. I mentioned earlier the option of a private plan. This is an option that's available in the statute for those employers that wish to provide this benefit to their employees but not participate in the public plan. But that can happen under certain circumstances, and those circumstances are these. The private plan must offer the same or better benefits as the public plan, and it can't cost employees any more than the public plan contribution, which is limited to 0.5%. They have to demonstrate the ability to administer the claims and benefits, and they have to hold a vote statutorily to seek the employee's approval of the private plan option. And that vote has to be a majority of all of the employees that work in the state. And even if they're out on workers' comp, or they're out on a disciplinary leave, it doesn't matter. All of the employees that work in the state have to have an opportunity to vote. And then finally, the paid leave authority has the right to approve the plan. As an employer, you're interested in a private plan, here are the steps that you would take. When you go on to register, you just let us know whether you plan to apply for a private plan by indicating that you plan to do so during the registration process. Soon, we will send you an email and call you back to the website so that you can upload the documents that you should have to indicate that you are ready to move forward with your private plan. And that is the declarations page from an insurer who's offering a private plan, something called the plain language guide, which we've developed at the Paid Leave Authority that you can give employees to explain what paid leave is and what a private plan is and the proof of your vote. And then we will review your application and notify you of our decision. And if you are approved, you will then upload your final plan documents, which is the policy that you'll be offering the coverage under. And all we're doing then at the authority is making sure that the policy is consistent with the declaration that you previously provided, and your approval is good for 3 years. I've said a lot today, I know that, and a lot of it is available, almost everything I've said actually is available on our website, which is ctpaidleave.org. Specifically, I'd like to call your attention to the employer site and the employee page on the website. On the employer site, on the employer page of the website, I should say, when you scroll to the bottom, you will see that there's an employer toolkit that summarizes everything I spoke of today. In summary, there's also an employee rights poster and a rack card, which is a shorter version of the poster that is downloadable and available for you to email, print, or otherwise provide to your employees. So you do not have to create your own documentation that explains paid leave. We've done that all for you. You can also see to the far right, there is an employee fact sheet, which is yet another version of the information regarding paid leave. And at the very bottom, you'll see we have a paycheck mailer. So most employers have been using this mailer. It is the #1 downloaded document on our site, explaining how paychecks will be changing this month and giving people an opportunity to visit the site. The site has something that is called a contribution estimator. So rather than have your employees inundate you or your HR department asking how much is 0.5%, there is a contribution estimator on the site that employees can go in themselves and put in whatever their wages are with whatever frequency there might be, and they can do that estimate of their calculation themselves. But what we're asking employers to do immediately are these things, which our date has passed, but please, if you haven't registered already, please go in and do so. Please register. If you use a payroll provider, please contact them to make sure that they are withholding the remittances. Educate your employees by downloading the documents that I outlined in just the slide immediately previous to this one, and come to the website regularly so that you can be aware of any updates that we have. We are here to help you. Thank you particularly to United Way, who is supporting us in our Contact Us Center. So please go to the Contact Us feature of our website. We do not have a call center because we're a startup and we don't have all the resources to stand up a call center, but we do have support through United Way. So if you use Contact Us on our website, then one of your colleagues will be answering those questions for you and getting in touch with you if they need more information to support you. There are also frequently asked questions and helpful videos that are available on the site. It's important I want to point out a couple of things about the site. One of which is that the entire content of the site, meaning videos, the site itself, and all of the materials on it are available in English and Spanish. And second, the site has been completely screened, every document, every page for accessibility. So if you have any people working with you that have low vision or are blind, the site should be fully accessible to them as well. So I want to thank you for your time today, and let's see if we have time to answer any questions you might have. So I'll stop sharing my screen.
Thank you so much for your presentation, Andrea. I wonder if we might be able to hear from Kate quickly and then go to questions, if that's all right.
That'd be great.
Thank you. So I'd like to provide just a brief introduction of Kate Quigley. We're so lucky to have Kate, who was available to lead this important effort. Not long after completing her bachelor's degree in social work at Wheelock College, Kate came to work at United Way of Connecticut. And in her 19 years on our team, she has filled with distinction a large variety of important roles, including as a 211 after hours supervisor, a 211 information services lead, and project manager. In mid-October, Kate assumed the role of interim director for the Connecticut Paid Family Leave Contact Center and quickly brought together and trained the team she now supervises, including 14 contact specialists who are working together with Kate to answer inquiries about Connecticut paid family leave on behalf of the authority. Kate is with us here today to explain the role that she and her team are playing to help move forward this important effort. And following Kate's presentation on her work, we'll move to your questions. Thank you.
Thank you, Lisa, for that warm welcome. And thank you, Andrea, for just this valued partnership. It's very exciting work, and we are thrilled to be a part of it. So I'm just going to share a little bit about our newly formed unit here at the United Way of Connecticut. I'm very excited to be taking on this challenge, and we are very excited also to be working with Andrea and her whole team at the Connecticut Paid Leave Authority. Our unit is a new unit here at the United Way of Connecticut. It does consist of 15 total staff, which includes myself as interim director. We have a team supervisor and 13 frontline contact specialists. So essentially our role is serving as the help desk, as Andrea mentioned, and triaging inquiries that are coming in through that Contact Us portal. So when someone fills out that web form, those inquiries come into a database that we're using, and we are able to respond to individuals both by email and then the additional piece of us being able to provide outbound phone calls to folks to walk them through and answer their questions. So we formed the unit very quickly, and we went live on November 12th of 2020. And just a snapshot of some case statistics for everyone. I ran a report for cases for just the month of December of 2020, and total cases that were created during that time were 4,354. Of those, only 324 of them were still open at that point in time at the end of December. And the average age of open cases by day at that point in time was just 5.9 open days for cases. So as we are serving our role and triaging the inquiries, we are working very closely with the authority staff to both troubleshoot IT-related cases that may come up in terms of folks needing to register for the program. We also consult very regularly with the authority's general counsel to ensure appropriate replies on legal questions or tax-related questions. We also have access to hundreds of amazing knowledge articles that have been published by the authority, many of which are also in the frequently asked questions section of the website, as Andrea mentioned. So we have those knowledge articles available to us right at our fingertips in our database that we use for the case management piece, that we can share and reply to folks by email with that vetted information. So as mentioned, we have the ability to make outbound calls. We have stood up as a call center for this effort to talk people through their inquiries and questions. We also have the ability to do some virtual calls and screen shares with clients to assist them with their registration process. So really being able to walk them through step by step if that's something that they need. The hours of operation for our unit are Monday through Friday, 8:30 to 5. And although our unit falls under the umbrella of the United Way of Connecticut and 211, I just wanted to make it very clear that the inquiries are not being handled by our 211 unit. We are a separate specialized unit for this effort. And so again, that main channel for reaching us is through the Contact Us portal on the ctpaidleave.org website. Our number is not widely publicized out in the world. So again, the majority of our work is outbound calling. And all of the staff are doing a tremendous job to really learn all of the finer points of this program. And they are very quick learners and very agile workers. So I'm very proud of the efforts that we have made thus far since the 12th of November. And we're really happy to keep moving forward with this. Very exciting work. So I will pause and turn it back to Lisa to see if anyone has questions. So thank you for your time, everybody. I appreciate it.
Thank you, Kate. And I do just want to call out that, as Kate said, this is a separate unit of our work. But one of the reasons United Way of Connecticut is so very pleased to have the opportunity to partner with the Paid Leave Authority is that we do have the full view of what we can do to be helpful. And given Kate's expertise and knowledge regarding 211, she is helping her team to think about ways in the future that they can think broadly about making sure to refer people in need back to the rest of the 211 team if there's something that we can do for them in another area. As my United Way partners here all understand, we're hoping all of us to move towards a more comprehensive way to be helpful to people, not just providing one referral in isolation, but to help them meet all their needs whenever we can do that. With all that said, Andrea and Kate, hoping that we can go to questions. There's one here, Andrea, that perhaps you could answer. I was told if Mr. Coyote lives in New York and works in Connecticut, he is eligible for the program. Is that true?
Yes, it is true. Hopefully he's a much more careful employee when he works for you than he is in the example that we provided. Yeah, so other than those who are self-employed, they have a residency requirement, but employees do not. So even if they live in another state but work in Connecticut, they are responsible for making the contribution to their employer, but then they are also eligible to apply for benefits come 2022.
Great, that's helpful. While we're waiting for other questions, Andrea, I'd actually like to ask one that came up with regard to our discussion with our Human Resources Department. And the question was wondering about this new provision which allows for a non-blood relative to be counted as if a family member. Would you help us understand how and who the determination will be made as to those quasi-family members?
Yeah, so this comes up quite often because it's a brand new provision and it's obviously not as clear as the law was before. We understand blood relationships and relationships through marriage. So what we're working on right now with the Department of Labor is to provide better criteria for determining what a family member is. As an example, and I was just speaking about this with someone yesterday, when I was younger, I had an aunt who was my mother's best friend, and I couldn't remember a time that I didn't know her. And so, but I could provide documentation, meaning I could come in with pictures from, my kindergarten graduation and my high school and my wedding and all of the major milestones of my life to show that she had always been a person who had been an important part of my life, although I was not related to her by blood. And she was very seriously ill at one point and passed away many years ago. But if this definition existed at the time, I would have been able to bring that documentation to my employer and say, she's my aunt for all intents and purposes. She's like a sister to my mother. And here's my proof that I've known her almost my entire life. And I'd like to be able to have some time to be able to care for her. So we're thinking that there might be photographic evidence, there might be affidavits that people can fill out, there might be specific forms that you have to attest to, not necessarily under perjury, but certainly under penalty that you have, if we find out that the person's not in your relation, so to speak, then you'd be liable to repay all of those benefits. So we want to make the penalty for not being truthful pretty significant to avoid that. So those would be the types of things that we're thinking about doing. It's not an easy thing to determine, and employers don't want, I know that the uncomfortable piece is not being in a place where you feel like you're really prying into that person's personal life. That's why we want to be able to provide more guidance. And so I'm hoping that by the end of February or maybe early March, that we'll have a much better idea with the Department of Labor, what they're looking for, so we can provide more guidance.
Thank you very much. That's
You're
helpful
welcome.
to know.
Yeah.
Are there other questions?
No. Okay.
Seeing none,
Yes.
just really want to thank you, Andrea, for your leadership of this important effort and for your time today.
Thank you.
And thank you also to Kate, who is such a great member of our United Way team. We will make this recording available to our United Way colleagues and on the United Way of Connecticut website. Andrea, can we also post your slides? Would that be possible?
Absolutely. Yes, Amber will make them available and the slides can be posted. That's not an issue at all. We're grateful, Lisa, for the opportunity to present to your colleagues today. Wish you well in your new role. I know you've only been in it since October, and it is something to start a new endeavor, particularly in the midst of a pandemic. But again, you're an extraordinary leader, and I think United Way is very fortunate to have you. And thank you to all of you for the incredible work that you do. Especially during now, you can see how important it is for us to really be that critical safety net to so many of our residents who really need us. So I thank you for continuing to be available and supporting our communities, because they really need us now more than ever. And thank you, Lisa, for your leadership. And Kate, thank you. Continue to do the fantastic work that you do, you and your team.
Thank you so much, Andrea. And thanks to all of you again for being here today. We'll send the link out and we wish you a good afternoon.
Thank you. Happy New Year to everyone.
Bye-bye.